Welcome. It still seems like some people are logging on and getting settled, so we'll just give it another minute before we officially start. But in the meantime, I just want to cover a few housekeeping bits so you all know how to behave and act while we are having this conversation today. If you would like closed captionings, we have a transcriber doing live closed captioning for us. You can click the closed captions button at the bottom of your screen. No attendees will be visible or audible during the webinar, so you won't be able to speak to us, and we can't see you in the side of the panelist table, but you can ask questions using the Q&A function at the bottom of your screen, and I very much encourage you to do so. We'll have lots of those questions coming up in the second part of the day. If you're an avid tweeter, social media influencer, or again, a member of TikTok Influence House, our Twitter handle is at Ada Lovelace Inst, so do tweet there. We'll be keeping an eye on questions as they come up. And finally, we are also taking recording of this event, which will be made available on our website within 24 hours of the event concluding. Wonderful. Well, hi, everyone. My name is Andrew Strait. I'm the Associate Director of Research Partnerships here at the Ada Lovelace Institute. For those of you who are unfamiliar with Ada, we're an independent research and deliberative body based in London with a mission to ensure that data and AI work for people and society. I'm very excited to welcome you all to this launch event for our Ada Lovelace report, Regulate to Innovate. This report stems from a series of workshops that Ada held in spring and summer around the UK's national AI strategy and its approach to regulation and governance. In its AI strategy, the government states has committed to publishing a national position on governing and regulating AI. And our report explores how the UK government might develop its approach to AI regulation in line with its ambition for innovation. Key to our findings is that effective, future-proof regulation can advance and protect fundamental values like human rights, democracy, and the rule of law, whilst also providing companies and developers with a space to experiment and take risks. The myth that innovation and regulation are somehow in conflict is not true, and we very much want to blow that up in this paper. However, unless the UK carves out its own approach towards the regulation of AI, it does risk playing catch up with other nations, or having to default to approaches developed elsewhere that may not align with the government's particular strategic objectives. Before we introduce our guests to discuss the paper, I'd first like to hand over to my colleague, Harry Farmer, primary author on the paper, who will walk through some of the specifics of the report. Over to you, Harry.
Thanks very much, Andrew. Just bear with me whilst I do the compulsory screen sharing, which shouldn't take too long. Great, so hello everyone, good afternoon. I'm Harry Farmer. I'm a researcher at the Ada Lovelace Institute, and I'm one of the authors of our report, Regulate to Innovate. Before we launch into the panel discussion, I want to provide you with a very quick overview of what we explore in the report and the kind of recommendations that we make. So today, we want to be using the report really as a jumping off point for a broader conversation about the regulation of AI. So I'm going to try and provide as much context as is necessary for the ensuing conversation, and hopefully no more. So the purpose of the report really, as Andrew has already mentioned, this is a report which is exploring some of the underlying reasons you might want or need to regulate AI at all, and how you do justice to those goals and to those objectives in concrete terms. And as you can probably guess from the title, it's a report that stresses the importance of regulating AI and the fact that clear, robust AI regulation is a prerequisite for sustained, publicly beneficial exploration and exploitation of that technology. So in the report and in the first section, we set out some of the underlying reasons for regulating AI, in addition and aside from fostering economic growth through the technology. We then look at some of the challenges for regulating AI systems, both in terms of those which are specific to the technology and those that are common to other emerging technologies and other complex technologies. And we also survey the different tools, regulatory approaches, and mechanisms that could be used to overcome those challenges. And then in the final three sections, we set out some general considerations for policymakers off the back of the things that we explore. We make some particular recommendations for UK government. And these recommendations that we make fall into broadly three clusters, one of which is around the development of new, clear rules for the regulation of AI, which are technology specific. Also around improved regulatory coordination and capacity building. And finally, we have some recommendations around greater support for non-regulatory interventions, which we think need to work in tandem with a renewed approach to regulation. So looking at the first of the three clusters of recommendations that we have, we call for a clear definition of AI systems to be established by the government. We believe that we need AI-specific, domain-neutral statutory rules for AI systems. And we also call for the development of sector-specific codes of practice for the regulation of AI. And these second and third recommendations are informed by the fact that one of the key findings of the report was that AI regulation requires bespoke, cross-cutting statutory rules for the technology. Bespoke because AI systems present genuinely novel legal and regulatory challenges. Cross-cutting because AI systems present analogous challenges across different regulatory domains, and because they present challenges that aren't necessarily confined neatly to existing regulatory domains or industries. And finally, statutory, because effective rules for AI can't be expected to emerge organically. In order to provide the public and AI developers with certainty about acceptable and unacceptable deployments of AI systems, we can't have regulation and the law developing incrementally and after the fact. There needs to be a clear rule book to which people can refer. And we mean this to be quite an explicit rejection of the idea that we can expect just adequate rules to develop through the courts or through the common law approach. A second key finding of the report, and a clear message that we got from the expert workshops that we did to inform the report, was that many of the harms and risks posed by AI systems are use and industry specific. So even if we want cross-cutting principles, there needs to be a degree of latitude for regulators to apply those principles to the peculiarities of particular domains. So what you have with the second and third recommendations that you can see here is the bones of a regulatory system that would combine cross-cutting rules with a degree of local variation. Now, turning to the second cluster, which is around regulatory capacity building and improved coordination. And to put it really crudely here, we have recommendations here about more money, more powers, and more formal coordination for regulators. And these are informed by some fairly well-accepted observations about the weaknesses of the current regulatory ecosystem and how it might apply to AI. In terms of capacity, we know regulators lack the capacity to regulate AI systems effectively. And here we're talking about technical capacity, but also really critically, we're talking about regulators' capacity to understand and to keep abreast of the legal and the ethical implications of AI systems. We also see that regulators need more powers to understand how AI systems are working. And also we've seen that many of the tools regulators need are still in development. Regulators will therefore need the permission and the resources to experiment with new regulatory techniques and to scale them when they find ones that look promising. And in terms of coordination, we know regulators need to present a united front when it comes to particular uses and forms of AI. This will require greater coordination. Now, when it comes to how to configure the regulatory ecosystem to be more coordinated and to make a most efficient use of hopefully expanded resources, we don't take a specific view as to how this should be done, but instead we set out the features any such system would need to have. So we set out a set of prerequisites. For the sake of time, I'm not going to go over what those are, but they are listed out clearly in the report. Finally, looking very briefly at the final cluster of recommendations. Here we have a set of recommendations that call for government to consider how best to use the UK's influence over international standards to improve the transparency and auditability of AI systems. And we also recommend that the government considers how best to maintain and strengthen laws and mechanisms which protect and enable other non-regulatory actors to hold developers of AI systems to account. So another clear message that we got from the report and from the expert workshops that we used to inform the report was that regulation needs to work in tandem with other levers. We can't just regulate in a vacuum. So what you have here is measures to ensure that the non-regulatory background conditions for successful regulation are enhanced and are preserved. Now, I don't want to eat any more into the precious discussion time and the time that our excellent experts have to talk over these questions in more detail. So I'm going to hand back to Andrew, but I hope this has provided some useful background and a good springboard for the ensuing conversation. Thanks.
Thanks so much, Harry. You've given us quite a lot to think through. Well, I am so grateful to say that to help us answer these questions. We're joined today by three fantastic guests. Reuben is an associate professor of human-centered computing, working between computer science, law, and philosophy. His work centers on data protection, machine learning, and the regulation of and by technology. Between 2018 and 2020, he was a postdoctoral research fellow in AI at the Information Commissioner's Office, addressing AI, machine learning, and data protection. Anna Thomas is the co-founder and director for the Institute of the Future of Work. Previously, she was a barrister specializing in employment law and appointed a counsel to the Equality and Human Rights Commission. Anna was head of the Future of Work Commission and is a fellow of IPR in the RSA. And lastly, Sana Khareghani is the head of UK government's Office for Artificial Intelligence. Her background is as a software engineer, and her office is currently drafting a forthcoming white paper setting out the government's position on its approach to regulating AI. We're very excited to pick through a few questions today, including what are the choices facing the government when it comes to regulating AI? What is the significance of robust AI regulation for the UK's AI industry? What are the different means by which regulators and governments might overcome the many challenges associated with regulating AI? And there may be many other questions that you in the audience would like to ask. So I very much encourage you again to use the Q&A function, and we'll try to work those in. But first, we'll begin with each panelist providing a brief 4 to 5 minute reflection on their thoughts around AI regulation, and then move on to the Q&A. I'll hand over to our first speaker, Reuben.
Hi, thanks. Can you hear me all right? Great. So thanks for inviting me, and thanks for producing this really interesting, stimulating, important report. I just have a few reflections on some themes from the report. So first of all, I think it's really important that when we're thinking about the future of regulation of AI, that we have in mind some kind of positive vision for what actually the end goal of all of this stuff should be. And I think the report does a good job of raising that as a question and putting forward some answers as to what that might look like. I think, starting with the question, what kind of AI do we want and do we not want? And that's essential to inform what kind of regulation we build around it. And I think there are different levels here. So there's a level of simply the point that you need regulation to create the right market conditions for innovation. You need a mixture of legal regulation, government funding, private investment, and so on to create innovation in general. But the other thing is that you also, even if you get those things right in terms of general innovation, not all kinds of innovation are good in the long run. We might still end up with systems that are built that are innovative in the sense that they're bringing products to market, but that still harm people and harm communities, which would ultimately undermine the development of AI in the UK. And I think if you need an example of how regulation it is important to enable markets, but also needs to be crafted to enable the right kind of innovation, you can look at the energy sector right now for an example of that. There's a huge amount of current AI products, which I would regard as snake oil. There's a great new book out by Frederica Cal-Tuna about this topic. I don't think you can make regulation that bans AI snake oil, but maybe it's as easy to define AI snake oil as it is to define online harms. I don't know, but I do think that you can have regulation that can help to snuff out fake snake oil AI. But I don't think the market on its own will do that, because I think in many cases, employers, companies who are deploying AI don't necessarily want an AI system that actually works in the sense that it accurately predicts and classifies things, but really what they want is something that can outsource risks to third parties, something that provides the appearance of neutrality and objectivity to things that they're doing that would otherwise be messy, value-laden decisions that they would rather not have to justify. So I think that avoiding that kind of fake AI that serves those purposes should be a goal of regulation. And so regulation has a role in enabling innovation. I think that's drawn out really well in the report, and specifically enabling the right kind of innovation. So second thing I really appreciated in this report was the focus on addressing regulation and responsibilizing different actors in the AI supply chain. So it's true that at the moment the AI supply chain can be quite complex. So there typically are large providers of AI services that are provided kind of as like commodities that individual organizations will purchase as an outsourced solution and deploy in their own contexts. But that leads to problems where these upstream providers have a lot of power to determine how the system will work, power to determine the expected methods of use and the expected ways that organizations can adapt these generic systems. But they often don't have the same level of responsibility that would be placed on the users of the systems. So often these are offered as sort of take it or leave it services, where they say here's the terms of the use, and that doesn't necessarily leave the people who are deploying the systems with all of the safeguards and abilities to interrogate and investigate the systems that they're deploying that they would need. So I think it's really important, and this is drawn out at various points in the report, to have regulatory attention at all stages of the AI development pipeline, both pre-deployment and post-deployment. And this is important because many of the most important harms that can arise from AI systems aren't immediately obvious at the point at which an AI as a service is put on the market. It's actually a dynamic thing that arises from deployment in particular contexts. So that was a point that I appreciated in the report. And then finally, I think if I were to put forward what I think could be a positive vision for the future of AI in the UK, it would be to recognise that the situation we have now with these generic AI as a service products that are on the market that do kind of general purpose things like recognising objects and images, or kind of assessing sentiment in text and so on. The model for deployment of these things is one in which I think there's not going to be that much more innovation. And I think where innovation may or could happen would be much more in contextual specific use cases. And so I think that there's a really important business opportunity for AI enabled services, which are not so much about the underlying technology, but are more about how do you employ it, how do you deploy it in a context where there are risks to groups, to individuals, where there are specific domain knowledge that's needed. And so rather than trying to compete with these big commodity services, I think the more important thing to address is how to make it so that AI is deployed in particular contexts with a view to the dynamic risks that arise in those contexts. So actually scale might be a problem rather than a benefit for some of these services. So services which are deliberately not meant to scale, but are meant to address the specific risks and needs of particular contexts. So I'll finish up there, but just a few reflections on the report.
Some really good points, Reuben. I think that point on sort of how we're thinking about innovation is a really key one, and I really like your points on the sort of different responsibilities that might exist depending on who's deploying them. And I appreciate you mentioning the snake oil book. I may be an author, one of the people out there in that book. With that, though, I want to next turn to Anna Thomas to give your reflections on some of the questions we've been raising in this paper and on the regulation of AI broadly.
Thanks so much, Andrew, and also Harry and Reuben. Always a hard act to follow. But I did love your report, Andrew, and particularly the explanation and messaging, very clear messaging, that sort of clear regulation was good for innovation and produced the right sort of innovation too, and the need to combine cross-cutting sort of statute, domain AI obligations and rules with sectoral guidance, which is something that we've done some recent work on too, and I'll try and build into my observations. So in the UK, I think, and globally, we're at a critical juncture in determining our path, as you've said, to AI regulation, and through that, really, the outcome of AI associated transformation for people and communities and society. And AI law isn't the sole determinant of that, but it does direct our our aim, our overarching goals, our policy, our standards, our behaviours, really. So in that sense, it will set our trajectory. And things are emerging all the time in this space. So even this morning, we had some new proposals from the EU for impact assessments and ongoing monitoring of automated decision-making impacts on platform workers. Nonetheless, there's still an unusual opportunity for the UK to lead a wider debate. As you've said in your report, if we really do manage to harness and align our strengths in sort of governance and regulation and academia too, as well as innovation, which we have in abundance. And so this debate that we're having isn't in a vacuum. There's a highly developed academic body of AI ethics that we have, which gives us the normative baselines that we have, that we need to move on now to statutory regulation. We think we now know which existing laws apply and how they do and how they not properly apply. We know where they fall short, and we'll come back to that in our discussion, I'm sure. We know also we've had some time to critique the EU proposals and where they're likely to fall short, which we'll come on to, I know. In the UK, there's lots of agreement about the need for a holistic ecosystem to develop our range of tools and methods for things like identifying those people affected, for evaluation and audit, and then taking appropriate steps. And we absolutely need detailed guidance from the regulators at a sectoral level, and they will be developed over time. We also, as the CDI roadmap published yesterday highlights, are conscious of the secondary advantages that there undoubtedly are of fostering a flourishing industry in the UK of an assurance, although we mustn't put the cart before the horse there. But the key issue remains, can we really leave it to a kind of patchwork, see as you go, pay as you go approach, or do we need to sort of bite the bullet and seize the first mover advantage and regulate really clearly for overarching cross-sector principles? We very much fall in that camp. And do think that it's necessary for regulation to do 4 essential things, and then as to how that happens, we can then follow that up, and the industry can develop around those prerequisites. They're so important, I will spell them out. It's identifying those who are affected, and that also serves as the basis for stakeholder participation. And your report is extremely strong, we thought there, and it's incredibly important that we continue with that work. And secondly, risk and impact assessment, and that's the stage at which all the tools and methods and technical audits will kick in. I should comment there that we're not seeing AIA just as a little tool that is untested. This is an overarching responsibility to undertake these things, which will incorporate guidance, compliance, best use of existing tools, future tools that we haven't designed yet, sandboxes and so on, to make things better. Then third, to take reasonable and proportionate steps in response to that analysis, and it should be for legislation to set that, to state those principles, and then as to how that happens, that will depend on your sector and the precise circumstances of the case and the guidance that follows. And then lastly, to set up an ongoing process for monitoring to sort of future-proof the regulation and allow for new or unexpected impacts. And in a sense that's quite bold to say that, although it's aligned, I think, with Sana's recent work on it, the CDI and your report. I guess we've been able to get there, we'd say, through a sort of deep dive into work. And so just to say a tiny bit about that it's really important in its own right, and socially and culturally, as well as the most important income, but and the thread, I suppose, that connects people's lives with communities and the economy. But it gives you a lens into high stakes environments, showing up the toughest challenges, and really why we must think about and require preventative action rather than wait till harms are done. I'm frozen, I think, but I'm going to continue anyway. It offers us a hotline to thinking about socioeconomic impacts in both the immediate and the longer term, and they're themselves getting increasing attention in the AI ethics debate, and I think more widely in government and internationally. And it also really demonstrates clearly why a solely sectoral approach doesn't work, because work isn't a sector, and so not to identify and meet the challenges that analysis in a work context have thrown up, won't fulfill the overarching and excellent aims of the AI strategy. I'm going to stop early because I've frozen in such a terrible position. But back to but look forward to more a little bit later, and hope my camera.
Thanks so much, Anna. You might have, I don't think you froze a terrible position, but your points were very well made. So I think that's the important thing. No, very, very good points. I think the drawing out there, I think that notion of sort of the first mover advantage and this sort of the need to sort of have coordination around regulation of AI amongst different governments. And I really want to call out the excellent work you've done on this AI Accountability Act around these 4 essential criteria: identifying those who are affected, undertaking evaluation of risk, taking responsible and proportionate action, and continuous evaluation. I think there's lots of questions that we could dive into in the Q&A from that. But before we go any further, I want to hand to Sana to give your first thoughts and reaction to some of the issues we've been discussing and this approach of AI regulation that the UK will take in future.
Thank you, Andrew. I want to start off by just thanking kind of Reuben and Anna for their incredibly useful comments, and obviously for the report that you have published. I wish that I was actually sat down taking notes rather than being on the panel. But I guess I can at least kind of let you know what we're doing and where your help and advice can allow us to move faster and more thoughtfully. So let me start by again reiterating how pleased we are to see the publication of the report. It provides evidence for how the UK might develop its approach to AI regulation, and I can tell you that my team is poring over and considering the recommendations that have been outlined, as you're aware, Andrew. The report recommends the development of new, clear regulation for AI, and that's great. That's really, really important for us to reflect on that, but also I think it's important to reflect that regulation is not the only way. For example, and as Anna was talking about, we should also look at the wider governance, including technical standards, assurance, and institutions with appropriate oversight, areas where the UK has long led in the world's sphere. So any new approach that we do take in this area will of course need input from regulators in industry and civil society. I'm delighted to inform you that the government has already taken significant steps to improve transparency standards and accountability mechanisms. This was another recommendation from the report. Last week, the Central Digital and Data Office, based in the Cabinet Office, published its algorithmic transparency standard for the public sector. This called for greater transparency around the use of AI systems. And it's long been supported domestically and internationally, including by this institute. The move makes UK one of the first countries in the world to develop a national algorithmic transparency standard, strengthening the UK's position as a world leader in AI governance. The standard is going to be piloted by several public sector organizations and then iterated based on that feedback before there's any formal endorsement from the Data Standards Authority, and we'll be seeking that later in the new year. Another first for the UK was something Anna mentioned as well, which is the CDEI's roadmap to an effective AI assurance ecosystem. The key deliverable from the National AI Strategy, another one of them, it sets out the steps required to build a world-leading AI assurance ecosystem in the UK. We strongly believe that a mature AI assurance ecosystem has the potential to be a multi-billion-pound industry in its own right. And it's an area which the UK has the potential to excel in. The roadmap identifies 6 priority areas for action, such as the need to develop commonly accepted standards and shape a diverse market of assurance providers. These areas for action will also factor into the new AI Standards Hub, which the Office for AI will be piloting next year. So a few of the things that both Reuben and Anna talked about are things that we are definitely looking at. We're still right at the beginning of this journey to ensure that the UK gets the governance of AI technologies right. We still have lots and lots to do. So I'd like to stress that this report for policymakers is now firmly embedded into the thinking of said policymakers. So we look forward to collaborating closely with the Institute ahead of our publication of the white paper on a pro-innovation and proportionate position on AI governance that encourages investment, protects the public and our fundamental values, and very, very firmly does not put regulation at loggerheads with innovation, but makes the rules clear. And as Anna said, we aren't starting from a blank sheet of paper. The position in the UK has been that very much a sector-focused approach, whereby regulators are looking at the application of these technologies and how they manifest themselves within their sectors and what they need to do. And what we're doing now is asking ourselves the question whether this approach remains fit for purpose, or are there other steps that we need to take in order to make sure that A, we are ready for anything that comes next, but B, we don't have any gaps and aren't missing anything. So I'll stop there, because I'm sure there's a lot to kind of unpick, and I hope that for most of it I can sit back and listen.
That's fantastic, Sana. Thank you so much. We've got quite a lot of questions flooding in, and for those who have just joined, if you would like to add more, please do. Moving into an open Q&A round. I mean, one theme that I'm picking up from some of the questions in the chat, and also from your remarks, is this question of how do we regulate technologies that are mostly coming from multinational companies in many cases. There are no sort of clear borders around these types of technologies. And there's been some questions of sort of like comparisons to the EU AI Act and attempts to regulate AI in places like the US or China. And it makes it for a very challenging position, I think, for the UK in terms of how to navigate that international conversation around how we regulate these technologies. Sana, I guess I would return this question to you first. What do you see as the way forward for kind of coordinating around regulation between different jurisdictions? And is there a way that you see that happening and through existing standards bodies or other kinds of mechanisms that currently exist?
That's a great question, right? There's a lot of work that's happening internationally in this. So we've already mentioned the EU's AI Act, the Council of Europe is looking at things like this. UNESCO has just released their ethical principles. The Global Partnership on AI is looking at this kind of things. OECD, the UN, I mean, I can just keep going, right? And you'll notice I haven't even started to list any of the standards bodies, right? So there's a lot of work happening in this. And I think the key across all of this for us is that we need to have our national position firmly in place before we then start to opine on on the international work that's happening now. Having said that, we are obviously sat across all of the work that's going on and making sure that we are aware of what's happening. But I think for us, the first most important step is getting our national position right. The point here, I think, also just to make is that there is a real need for clear, coherent governance systems that inspire confidence and trust, and that help drive innovation and direct responsible development using these kinds of technologies. And there are, we need to have a recognition for the need to facilitate international interoperability to help support businesses, especially SMEs, as they move out into the market. So these are things that we are definitely thinking through. And yesterday on another panel we were on, Andrew, you and I, Luciana Fleury talked about the Brussels effect. And for me, I think, it's the Brussels effect plus all these other things that are happening internationally that we need to be aware of, and that our whatever national approach we take needs to consider, because otherwise what we will do is we will either lock down things here, meaning that our companies cannot go abroad or sell abroad or commercialize more widely, or stifle the possibility of a burgeoning AI economy, right? And so what we just really need to be kind of aware of what's happening. And so for us, international collaboration, open dialogues to understand different approaches, opportunities and challenges, around issues such as transparency, fairness, liability, accountability. All these things are really important, and we are trying to say as much across it as we can.
They're really good points. And I think a sort of related topic comes up when we talk about the sort of transnational challenges is also the future-proofing element of regulation. This is something I think a few comments, including Peter Kosmala, hit on about how can, even just looking at just the UK, create regulation that is able to be at pace with the fast development and deployment of these technologies in different sectors. Reuben, I know this is something that you've talked about briefly, touched on it in your opening remarks. I was curious if you had any thoughts on sort of what are ways that you could see a regulatory system future-proofing itself to address that challenge.
I think it's always there's always a desire to make things simple, but I think we've got to recognize how complex AI systems are at the moment and how complex data flows are, not to mention how complex all the different problems that can arise from them are. So I think there's always a hope to make things as simple as possible, but I don't think we should make things simpler than necessary to address those challenges. So I think that's an important thing to keep in mind with this stuff. I don't know if you can future-proof these things. I think there has to be a certain amount of flexibility to deal with them. And also I think it's important to recognize that different areas of regulation have historical legacies that are often still worth upholding. And so when it seems like there are bits of legislation that seem outdated, or two areas of regulation which seem to overlap, that's not always a problem. It doesn't always mean that one of them has to be redundant because it's covering the same, apparently the same system. It might be that they're covering the same system but for different reasons, or with different obligations or rights, or risk assessment methodologies, and that might sometimes be overkill, but it might also be a good thing. And when we're dealing with such a complex space, I think it's good to have multiple checks and balances and safeguards in place. So yeah, that would be my kind of 2 cents on that. We can't totally future-proof things, and sometimes the complexity needs to be recognized.
That's a really good point. Yeah, Sana, did you want to comment on this?
Yeah, I totally agree with Reuben. I think the one thing I would add is that helping to upskill our regulators and make sure they have the right capacity for these changes is an area that helps us with kind of recognizing these gaps. And I know that the ICO, Reuben himself has done a stint through the regulators. I think these are the kind of things the regulators more broadly should do across the board. And I know that that was reflected in your report as well in terms of upskilling and capacity building.
Very good points. Yeah, Anna, did you want to comment on this question?
Only very briefly, because I agree with Sana and Reuben. I think having principles as well, having principles helps with future proofing, specifically building in a process and allowing in regulation for the capture of impacts through sort of stakeholder engagement and participation that you haven't anticipated yet will help future proof it. And thirdly, as Sana has said, really empowering the regulators existing and potentially future to do the range of activities that they do at the moment, but additional ones in terms of both investigation and cases and sort of specialist capacity and sandboxes as well, to sort of really bottom out those tricky areas of impact assessment and proportionate adjustment, such as the equality ones, and making sure that they actually promote equality.
Yeah, it's a very good point. This notion of regulator capacity and coordination is really interesting. One of the many things I had not realized going into this report is that different regulators across the UK have very different levels of capacity. Some are significantly larger than others, and I think that raises a huge coordination challenge. One of the other points that I think has come up in the Q&A is around how do we regulate the use of AI technologies in spaces that are already heavily regulated, like medical devices or in employment. And I guess I was curious, Anna, if you had sort of thoughts on how to go about doing that. How do we create regulation around AI that is either complementing or fitting within existing regulation, or should it kind of eat over it? You know, curious your general thoughts on how we would approach that.
Well, if you take employment, yes, there's all sorts of regulation. And so we've done, for example, involving Reuben and others, a quite a detailed mapping of how the Equality Act and in the GPDR in particular do cover particular, traditional and new challenges in the workplace. And the quite clear conclusion was that they don't, that the particular challenges that relate to new AI capabilities are not sit between those regimes, in particular those that relate that are linked to equality as the outstanding one, and the way in which the sort of the data sets that train the technologies and that reflect past patterns of behaviour and resource project things into the future. And so I'm not so I don't think so. It doesn't. So they would sit within it. They wouldn't sort of override it, but they would fill those gaps and address those new challenges.
Really interesting point. Reuben, I want to turn to you about another question from the audience about this notion of open source, which I think is really, once you unpack it, quite interesting. Open source is, I again didn't know this until quite recently. Open source is a fairly foundational part of most of the technologies that we use, and I wonder if you have thoughts on how you would, in theory, regulate technologies that would be classified as such.
Yeah, that's a really great point. I suppose first point, open source can enable innovation, but it can also be a tool that's used to stifle it by powerful companies. So if you can give away something for free that everyone then comes to depend on, even if you're not selling that thing, you can leverage it to wield power. And so I think we see that to a certain extent with some large tech companies that have developed very popular open source frameworks. So that's one point. But the other point, I think that there's a huge issue because so much this comes up in the EU AI regulation. When is something put on the market? If I write some code and put it on GitHub, and anyone else can come and look at it and like copy it and build the same model I built using the same data I put up openly or that's shared somewhere else openly. Did I put the model on the market, or was it the person who came and copied my code? If they then put that up somewhere else and then it gets integrated into a platform where other customers can come and like try out different models and deploy them in their context. So it's not an open source problem as such. It's a more general problem of like, at what point do things get put on the market? And it's not sufficient to say when they're for sale, because there can be lots of harmful, like I said before, that there could be lots of harmful open source or free AI systems, models, frameworks that could be harmful and that could be used to wield power in different ways. But then on the other hand, you don't want to make it such that nobody can share like code openly, especially for like non-profit academic purposes and so forth. So yeah, it's a tricky one. I think the principles of open source have yet to be fully applied to AI systems that are in use today, because there's always some level of capture, whether it's the fact that an open source tool is ubiquitously used on a hosted platform from a large tech company, or because it uses other components which are not themselves open source.
It's a really good point. I think it also connects in with the question of sort of how do you create an ecosystem of auditing and assurance, which I know this government has fantastically done. I think a great roadmap that was released yesterday on assurance, and this notion of when you run up against trade secret concerns or other kinds of concerns, how do you get past that? I think is many issues that I think this paper does not unpack, but I think have yet to be answered. You did mention the EU AI Act, and I would be remiss if I didn't use this opportunity to ask each of our panelists what they think works from the EU AI Act they'd like to see replicated here, and things that they think could be done differently. And Sana, I'm so sorry, I'm going to have to turn to you. I'm thinking hotspot on this. I'm curious if you could share your thoughts on what you would like and what you would probably get rid of.
So I think that the outcomes of the EU AI Act in terms of valuing our citizens, our own values, democracy, human rights, I mean, those are all very much aligned to how the UK and what the UK wants, right? To be able to achieve the best from these technologies, but safeguard our society, our values, and our, you know, our way of life. The question we're asking ourselves now is whether the means by which the UK achieves those same objectives is the same, or, you know, and how much it aligns versus diverges. I think it's less about, you know, wanting a different thing. It's about questioning whether the approach needs to be the same. And I think for us right now, it's about considering that whole picture, which is the role that regulation plays, the role of the wider system of assurance standards, audits, evaluations, you know, all of these other things that sit within that landscape are all important, right? And the EU has taken a very risk-based approach. We are looking at this very much from our starting point is an application-driven, sector-based approach to say, you know, what applications, what existing regulation do we have? What are the gaps? How do we make sure that, you know, those gaps are covered? What more is needed? So we're aiming for the same ends. Our approach in interrogating those questions are different to start off with, and we're still at the cusp of finding out how closely or differently we come out at the end of this. But we're in the foothills, so I can't kind of one way or another say, you know, this is exactly going to be aligned and this is exactly going to be different.
That's totally fair. I think very, very good points about kind of the kind of core focus on values. Anna, I'm curious sort of your thoughts on this question of what if in the EU Act would you like to keep and see changed?
Like Sana, this is quite provisional and work in progress, it's good that there is a draft out there that's that can highlight things that we need to look at and things that we haven't looked at. I mean, light touch criticisms are that there are some issues around the risk thresholds that are set and the application of those, which is not a new problem, but highlighted perhaps in the EU Act. And again, if I can go to insight from work, so our work, our research says there's actually quite limited value having a risk that a sort of complex risk threshold in a work context, that it might be more constructed, sort of easy to follow if you simply say, well, if it's going to impact you know, terms or quality and conditions of work, we've set it out in our model, then you should do one. So there's that point. There's quite a lot of marking your own homework. You know, I'm sounding like a real Brexiteer. In the EU Act, there's not a lot on sort of impact analysis. So it could be arguably it's slightly more, it's not sort of forward-looking enough in that respect, and could do more, I think, to sort of really integrate, again, participatory mechanisms, but thinking about those sort of tougher impacts. And we do have an opportunity in the UK to think sort of slightly more holistically about the nature of sort of united impact assessments now. That's enough, I think, for the time being.
Very good points. I think that notion of impact and participation is another key thing that we didn't quite get to in our discussion earlier, but I think is a very, very important one to center. Reuben, curious for your thoughts on this question around the pros and cons of the EU AI Act that you'd like to see.
Yeah, so well, I think there's a few points. Anna just made the point about marking your own homework. I think that's one of the big problems, that that the way the Act is structured, it has these nice substantive things that need to go into a risk assessment, but ultimately those things will be outsourced to standards bodies. and the users of AI systems will just have to self-certify that they're following the instructions on the label of the product, the AI product. So I'm worried about that. Also worried about preemption. So at the EU level, this is an act which is regulating AI, which would make it so that if a member state were to try to create more specific AI regulation, say for gig economy, the thing that just came out for gig economy workers, that would potentially be could be challenged by tech companies saying this is preemption of the act, which is already regulating AI, so you can't make specific bits of regulation around it, which would be a problem. And I also think that various people have made this point, but that product safety is not necessarily the right framework for dealing with the risks of AI, which are much more about, it's not about, is this saw like capable of taking enough weight, or is it going to get too hot? It's like, what are the complex ways that this is going to interact with people's rights and freedoms and equality and so on? And that's something that has to be much more contextually investigated, and you have to have stakeholder involvement to figure out what those risks are going to be in particular contexts. So what I'd like to see is more what I thought would be a good element of the AI Act, which would have been to place more responsibility on upstream providers of AI systems. And I think, well, I was hoping that that's what the AI Act would do, but I'm no longer convinced that that's what it would do. So yeah, it needs to recognise that the important harms arise in particular contexts, and they're not things that are inherent in the product that's put on the market.
It's a really good point, Reuben, and it's actually kind of touches on I think what we'll get to is our sort of final comment, final set of questions around the tension that I think we often see in proposals of regulation between the sort of global or national and the local. I think your point about context is really key. What kinds of mechanisms, both regulatory and industry practice, does it take to ensure that developers are thinking about the local or specific context they're being deployed into? And I think one of the questions even asks, sort of a variation of this, of how much of that power should be devolved to different regulators or to different sort of local authorities. I was curious if any of the panelists, and I guess we'll start with Anna, because I think your paper on impact assessments touches on this quite well. If you have any thoughts on sort of how we bridge that gap, how do we bridge that sort of global, national and local challenge in the regulation of AI?
I think that the principles are derived now from international as well, although we have in fact fed into them significantly. That's plainly international, and there will have to be sort of frameworks to follow that up. At a national level, the role of the government is to set those clear standards, frame that overarching obligation, and require the things that really must be done. And then the regulators would, in addition to, provide huge amounts of sort of detailed guidance and tools, the CDI2, yourself, and other institutes, yourselves, on how you would do that, and sort of, experimentally and drawing on sort of research of all different and practice in all sorts of different areas, and that would be supplemented, of course, by the industry bodies who would develop standards that may become sort of compliance and certification, which is something that could then be introduced where the needs arises.
Really good points. Well, we've got about 3 minutes left, and I'd like to give the panelists a chance to sort of offer any final reflections on what they would like the next year ahead to look like when it comes to the regulation of AI, either in the UK or abroad. Sana, I suppose we'll start with you, and then we'll go Reuben and then Anna.
Well, we've got a lot of work on our plate right now. So to pilot the AI Standards Hub, and to publish the AI governance white paper next year. So my goal is to develop, to be much more clear what our national governance position is here in the UK, and be consulting on that. next year, so that we can approach the questions internationally on a much stronger footing. So, and that in order to do that, we are going to need the help of people like Reuben and Anna, yourself, Andrew, and the Ada Lovelace Institute, but also the people who are asking the questions, very, very good questions on the chat. So please get involved and make sure that you are feeding in as we develop what these positions are, and then formally responding to the consultation when it goes live, please.
Fantastic. And Reuben, your thoughts?
I suppose wish list. I think there are some clear cases of AI systems that are in use today which should not be in use, which don't work, which harm people, and which I think we already have the regulatory tools to deal with them, and I think that they should be dealt with. More positively, I think more involvement of civil society, trade unions, local government, to get to the question I think Peter raised, through things like citizens' juries, through other forms of stakeholder engagement, to sort of outline, well, what would be positive examples of use, starting with them. And I'm also excited to see what's going to happen with different regulators collaborating with each other. So things like the Digital Regulation Cooperation Forum being one important development there, I think.
Brilliant. Yeah, that I very much agree with you on the regulation coordination piece. That is a very exciting development. Well, that leaves us with Anna with the last word.
I would like to see the gold standard, we've said, would be an Accountability for Algorithms Act, and we've set out proposals for that, which could be rebranded by Sana. And also ideas in it could, if that as a sort of plan B, could and we would like to see incorporated in the AI strategy. Very strongly agree with what Sana has said about the need for sort of clarity as soon as possible, and drawing on your important work, this report, this launch event, as well as our own, that really strongly points to the third route in the AI strategy that's identified as the 3 paths. I think our sort of combined research has knocked out the first 2, but my last point would be so we can proceed with that, but at the same time, so not seeing it as inconsistent, but parallel to everything else we've said about the assurance industry, boosting regulators, developing the AI healthy ecosystem. So to see all those working together, but keep the high road is what we'd like to see. Thank you.
Thanks so much, Anna and Sana and Reuben, for your incredible comments today. And thank you all for listening and joining in. We really appreciated your wonderful questions. Well, that's all we have time for today. Again, a recording of this will be made available on our website if there's anything you missed. But before we go, I just want to give one last final massive thanks to our speakers for joining us. Thank you so much. I'm sure this will not be the last time we talk about AI regulation in the next year or even years to come. So we look forward to the next conversation with all of you. Have a lovely rest of the day. Take care, everyone.